A very warm welcome to all of you. I am Chandni Bajaj and I present to you this wonderful episode of our legal awareness series, Just Justice. As it is said, to learn is to grow. So we must keep learning every day of our life. In today's episode, we shall be dealing with various aspects of joint in the family and coparcenary. To enlighten us about this topic, we have our legal expert, Dr. Gaganpreet ma'am, with us here in the studio. A very warm and cordial welcome to you, ma'am.
Thank you so much, Chandni.
And now, to begin with, ma'am, please do tell us what is the difference between joint in the family and coparcenary.
As regards joint in the family is concerned, it's a wider concept, and the members, they are as I told you, that the senior most male member, along with his wife, his children, his grandchildren, the daughter-in-laws, granddaughter-in-laws, they all are members of the joint in the family. Coparcenary is a narrower unit within the joint in the family, and it comprises of only male members, that is 4 generations of males in the line of descent, starting from the father, son, son's son and son's son's son. This is the composition of the coparcenary. As regards the membership to joint in the family is concerned, it is open by way of marriage, by way of birth, by way of adoption. As regards coparcenary is concerned, the membership to coparcenary is open only by way of birth or by way of adoption. As regards, there are certain disqualified coparceners as well. They remain the members of the joint Hindu family, but in case of disqualified coparceners, they are not to be considered as members of the coparcenary if they are disqualified. So, as regards joint Hindu family is concerned, there is no precondition of the existence of property, but as regards coparcenary concerned, coparcenary will come into existence only when there is some property or the joint Hindu family property. Only then this coparcenary will come. And as regards the rights are concerned, the coparcenary, there is a birthright in the property. The members of the joint Hindu family, they do not have the same birthright or the same interest. Rather, the interest they keep on varying also, because there are joint Hindu family being a wider concept, the members, they just have the right to maintenance. But in coparcenary, it is always joint in the sense that they always have a right to property in case of coparcenary. So, these are the basic differences between a joint in the family and a coparcenary.
Okay. And Dr. Gagan, as you mentioned in the last episode, we had discussed about the coparceners having an advantage of partition. So, would you please elaborate on this topic about the partition that coparceners can effect?
Partition is a very, very important concept as regards joint Hindu family property is concerned, because the shares will get separated only once partition is initiated. It can be at the instance of the coparceners or it can be at the instance of the karta. But once partition takes place, the shares get separated and each and every coparcener will get a separate share, and it will be now categorized as their separate property. Property which initially was joint Hindu family property, now that color will change and it will become separate property once partition takes place.
Okay.
And partition, it is once you form that intention and it is communicated to the other coparceners and they have the knowledge of that partition, we say that the severance of status takes place. Okay. Severance of status, because initially I discussed with you that there is community of interest and unity of possession, and community of interest will come to an end once that intention to get partition is conveyed to the other coparceners. And the term which we use is severance of status. The status which was initially joint, now with the formation of that intention and that intention being conveyed to the other coparceners, it has now resulted in the severance or in the separation of that status. Although the actual physical demarcation or separation of property will take at a later stage, because it's not possible that today I think that okay, I have 4 properties which is jointly owned by the joint Hindu family, and I seek partition, and immediately that those 4 properties will be partitioned equally amongst the members. It will take some time, and when the actual physical partition of the property takes place, we term it as partition by way of meets and bounds. That is actual physical demarcation of shares. Now the coparceners, they know that which share of the property belongs to which coparcener. Because earlier when the property was joint, nobody can say that okay, this share of the property or this part of the property belongs to me and this part of the property belongs to the other coparcener. Nobody can say that. The shares will be demarcated or separated only upon partition, and in normal course we say only the coparceners and the karta, they have that right to conduct such partition.
Okay. Dr. Gagan, as you just said, that there has to be communication of the intention. So this communication has to be to all the coparceners, or just to the karta would be sufficient?
Yes, just the communication to the karta will be sufficient. The only thing is that intention has been conveyed that I want my separate share, and once that intention has been conveyed to the karta, it is sufficient. It's not necessary that each and every coparcener should be intimated separately. The intimation to the karta would be sufficient communication for the partition.
Okay. And is there any specified mode of communication, like it has to be written?
There is no such specific mode of communication. It can be oral, it can be written, it can be the case for partition can be initiated by any of the coparceners. Any mode can be taken up by the. So there is no such fixed thing that okay, only if this step is initiated, the communication will be considered to be as. It can be by way of a letter, it can be by way of a telephonic communication, it can be by way of email in today's time, if that is so. So we are talking about the old Hindu law. So the thing is that the communication should have been there and the intention should have been conveyed. That is the whole thing.
And what all subject matters partition can take place?
See, there are certain properties which can be partitioned, and there are certain properties which cannot be partitioned by the very nature of their existence. Like for example, the staircases, the well, the tanks, which were the common properties in the older households, Hindu households. These were common things. Yes. That if the property has a staircase, a right of way is there, you cannot partition or you cannot put it different shares that okay, this share, this part belongs to me and this part belongs to the other. And the idols, yes, the idols which we worship, they cannot be partitioned. And certain things like for example the clothing, items of clothing are there, utensils are there, even for that matter ornaments are there, they cannot be partitioned as such. You cannot, vehicles are there, yes, the animals are there, you cannot partition them, you cannot divide them into parts and say that okay, this part belongs to me and this part belongs to the other person. So by the very nature of these household goods and certain properties, like for example I just gave you the example of staircase, right to way is there, well is there, tank is there, idols are there, they are exempted or they cannot be partitioned at all.
Okay, so this brings me to my next question, which is, please elaborate us the principle of ovality.
See, as I told you that certain property, they are impartible. So those properties which are impartible or you cannot partition, so in case a partition is actually initiated and you have to divide the shares, so whatever the intention should be, that partition should take place in such a manner that that property, it should not lose its intrinsic value. Because if you partition a particular property and the intrinsic value of that property is lost, then you do not get anything out of it. I will give you one example. Like for example, there is an antique piece or ornaments are there, and if you try to break it into different portions, it will lose its value. That ornament will not be of any use to anyone. It will be just a piece of a metal. So, what I mean to say that in case of impartible properties, if the partition cannot take place, or if at all we go in for partition and it loses the intrinsic value, then it's of no value to any of the members. So, in that case, the property is to be given to one of the coparceners, and the others, they will be equally compensated for, they may be given some other property, or they may be given the money value equivalent to the share in that property. And this principle, that giving of the equivalent value or money consideration or equivalent value of property to the others without partitioning, without breaking that property into pieces and going by the money consideration and one of them retaining, or at times just as a practice, not by the principle of ovalty. Many a times, for example, with respect to the idols of worship, the co-partners, they may decide that okay, they will enjoy that property by turns.
Yes.
Let's say there is a temple or idols are there, they will say that okay, for 1 month or for 1 year I will take care, or I will be responsible for that, and for the next month or the next year, whatever is the time period decided amongst them, they can the other members, they can enjoy it. So, depending upon the nature of the property, that decision can be taken. But as regards the impartible property is concerned, they have to find a via media, and when it is used in such a sense that the money consideration or the equivalent value of that property is given to another members who do not get a chance to get that particular property which is impartible. This is how this principle of ovalty works.
So, this principle is quite a midway to avoid the conflicts.
Yes, basically.
So, please also tell us what are the consequences or the effects of partition.
See, as whenever partition takes place, now the property which was earlier joint in nature, it now changes its characteristics. Now it becomes the separate property, and once it is separate, it can be used in a manner the way that person wants to. The person can sell away that property, make a gift of that property, make an exchange of that property. Nobody can put a limitation, because earlier when it is an undivided share, it is part of the joint Hindu family property, nobody could use that property or could claim a stake over that property. And once it is a separate property, and for example, let's now if the person who has got the shares separated, he unfortunately, if he dies,
okay,
and he is a single person, or he just has a wife, let's say, of talking about the old Hindu law only, the property actually as far as the codified law is concerned, the property will devolve by way of succession, and it will not go by way of inheritance, which would have otherwise gone by that. So, now once it is separated property, a separate claim is there on the property, and the person can utilize that property according to the way that person wants to use.
Okay, so this is gives it a completely separate right.
Yes.
And could you please apprise us about the instances of involuntary partition?
So, as regards involuntary partition is concerned, there are certain instances under the old Hindu law that if the person conducts in certain manner, he will be expelled from the joint Hindu family. Like for example, if the person converts into a non-Hindu religion, so that was an automatic expulsion from the joint Hindu family or the coparcenary, as the case may be, and the share in that coparcenary will be fixed on that particular day. Whatever was his share on that particular day, it will be fixed. He will be given that share, and he is expelled from that. So, it is not a partition which he has asked for, but just by the conduct, if he has if he has acted in such a manner, he will be considered to be as out of that coparcenary. Another instance was marrying under the Special Marriage Act. So the option of, because now we have Special Marriage Act 1954, but there was another older version of the Special Marriage Act, or the secular legislation of marriage. And if the person opted, this is actually, these are the different stages of development of Hindu law when this act came into being. And if one of the co-partner opted for getting married under the Special Marriage Act, and that also to a non-Hindu, it was like a expulsion.
Okay.
One thing is that if you have opted to get married under the Special Marriage Act, that is a expulsion from the, because you have not opted for the regular mode and you have opted for the something which is not expected from a Hindu as such. So going by the secular way, it was considered to be as an expulsion or automatic or involuntary partition. And the third is with respect to the other aspects, that adoption, in certain cases it is not exactly an involuntary partition, but where the child is given in adoption to another family. So that share in the property which he originally has in that natural born family, that will be, in a way, there are certain consequences to that regard, although it does not actually form the context of involuntary. But with regard to the conversion and marriage under the Special Marriage Act, that is these are the basic instances of involuntary partition.
And could you also please tell us that if a co-partner willingly decides to forego his property, how can that be effected?
See, if a co-partner does not want to have a share in the property, he can just convey that intention and his share will be divided amongst the other co-partners. There is nothing which prohibits him from. He has the share in that property, and if the partition is taking place in the family, somebody else has initiated, and he say that, okay, I do not want any share in the property. So that share will be blended in the whole, and the other co-partners, they can be given.
They'll get
It
that
is
share.
like it is up to him. He can take the share and give to any specific member with whom he is more attached, or he can just generally say that, okay, I forego my share.
Okay.
It is up to him, but that right is definitely there with him. Once a co-partner, a person is born in the co-partnery, he has a birthright in the property. Whether he is claiming that right or he is foregoing that right, that is totally upon that particular co-partner.
Okay. And in case a partition takes place, who all are entitled to get a share in that case?
See, as regards whenever partition takes place, the general thing is that each and every co-partner who is eligible, they will get a share in the property. Although there are certain co-partners who may not be active, or they cannot be considered to be as what I can say. Like, for example, I'll explain it with the help of example. Let's say there is a co-partner who is of unsound mind.
Okay.
Or let's say if there is a co-partner who is a minor. Such person, they cannot ask for partition. They cannot initiate partition on their own accord. Maybe for minor, the next friend of minor can do so, but in their own capacity, they cannot do so. But whenever partition will take place, they will get a share in the property. The share will be provided to them. Another instance is that many a times a child is not yet born and is in the womb of the mother. That when at that time when the partition was sought by the, or when it was announced by the karta, let's say, or the father, and one of the daughter-in-laws or the wife of the karta, she is expecting.
Yes.
Now, if that share is divided amongst the living persons and no share is reserved for that unborn child, so it will be considered to be as something which is not proper. And even under the old Hindu law, a share, when such partitions were initiated and one of the females or one of the daughter-in-laws, she was expecting a baby, a share was reserved for that particular child. If the child was born alive as a son, that share was allocated to him. If the partition is actually conducted at that stage. Normally, that partition will be postponed till the date when the child is born. And if it is initiated at the earlier stage and the child which is born is a baby girl, then the share will be reserved for the marriage expenses or for her education. Certain expenditure or certain property will be demarcated, and the rest will again be distributed amongst the members. So, whenever partition takes place, a share will come to all the co-partners. There are certain, with the passage of time in the old Hindu law itself, there were certain developments, and certain females, they were also provided with a share.
Okay.
Although they could not ask for partition, but whenever partition was there, they were provided with a share in the property. The females, they were like the father's wife, second is the mother, and the third is the paternal grandmother. These are the three females who were given some share in the property under the old Hindu law. And these are the members who will be given a share whenever partition takes place. Otherwise, all other members of the joint Hindu family, they are just entitled to right to maintenance and they could not get any share in the property. But yes, these members, the co-partners will get a share, and in case of certain category of females, as I just explained, they will get a share in the property.
Okay. This leads me to a question, two questions actually. First, what if a stillborn child takes birth? In that case, the share goes to him. And is the keeping the share of a child who's in the womb or keeping the share of a minor child are exceptions to the principle of involuntary partition, because they have not asked for partition, but still it is there?
No, see, it is the protection of the right of such a child who is ultimately, if that child is born as a son, and if that person or that child is going to be part of the coparcenary, if that partition has not been initiated at that stage. So, just to protect the interest of that child, the share will be reserved if partition takes place at that stage. Okay. Normally, as I told you, the partition will be postponed to the date of that it will be after the birth of that child. But in case the partition is conducted at that stage, then share will be reserved if that child is born as a son and he is that son is born alive. The share will be given to that son. In case that child is born as a daughter, the keeping aside the marriage expenses and the expenses for the education, that will be set aside, and the rest will be divided among them. You also asked the question that if it is a stillborn child, if it's a stillborn child, this share which has been, if the partition has already taken place and a share was reserved for that child who was in the womb of the mother, that will be again redistributed amongst the members. Okay. And so, it's not so that it will lay in abeyance, it will go back to the respective co-partners only.
So, this leads me to my last question, which is about the recent developments which has taken place with regard to women in as having the property rights.
See, as regards the women's right to property is concerned, I told you the context that under the classical Hindu law or under the old Hindu law as such, the women, they never had the property rights, they were not entitled to property at the first instance, and they were not members of coparcenary. The second stage of development is that yes, after certain time period of time, certain category of females, they were granted property rights, like I told you that the father's wife, mother and the paternal grandmother, as the case may be, these were the three category of females. Another stage of development, or I would say that in the direction of codification, it's a Women Rights to Property Act 1937, which is a very, very important legislation from the perspective of the women property rights, because in this legislation, a share to the widow of the co-partner was provided. Okay. I would just explain it, that let's say one of the copartner dies without any heir, without any son, but he leaves behind a widow.
Okay.
There are other copartners, and under the coparcenary, I told you that there was a rule of survivorship. Now, under the old Hindu law, the shares would have gone by way of survivorship to the surviving copartners. But with the passage of this particular act, what happened was that now this widow, in case the husband who is a copartner dies, his widow will step into the shoes of the husband, and whatever was the share of the husband in the coparcenary, that will come to her, but it will be only for her own lifetime. It was not absolute property right, it was a limited property right, and it was only for her lifetime. She could not dispose of that property, she could not give that property, she could not transfer that property by any means. But she would enjoy that property for her lifetime. She can give that property on rent and enjoy the benefits, whatever may be so. But once she is dead, the property will go back, or it will revert back to the heirs of the husbands, who are termed as reversioners.
Okay.
So, here by way of this particular act, the limited ownership rights were granted to the Hindu females. This was a good step in the, you can say, in the series of providing property rights to the females. But the main or the full property rights, if I say it more specifically, they were granted to the Hindu females only by way of codification in the year 1956 with the passage of Hindu Succession Act. That was for the very first time in the history of Hindu women that the women were granted full and absolute ownership rights.
Okay.
So that is these are the stages of development. And yes, now with the recent amendment of 2005, they have even been granted with the coparcenary rights, and which has led to again widening the ambit of their property rights, which is itself a very, very big topic in itself. But these are the stages of development, that how women property rights have been progressing over a period of time.
Yes, so yes, with the time, the women are getting their rights,
Yes,
it's
yes,
progressing.
Yes.
So with this, ma'am, we come to the end of our episode. It was very delightful to have you here and learn about so many things. Thank you so much, ma'am.
It was my pleasure. Thank you so much.
And I hope every one of us has equally learned the new aspects related to joint Hindu family and co-partners, and especially we have also learned the women rights with regard to the properties. And I promise you that we will again bring to you another great episode. Till then, stay tuned with us. I'll bid you farewell till then. Bye-bye.